Good afternoon, good afternoon. This is Jamaica Live. We're on Bridge 99. And as at 1 o'clock, we'll also be on Ira Jam in New York. Today is the 14th of February. It's Valentine's Day, and I want to wish all the lovers out there a happy Valentine's Day. It is also the day when the Disabilities Act comes into effect. And hopefully that will provide a new day, a new era of facilitation and empowerment for persons who have to live with disabilities. And you know, we had Senator Floyd Morris on the program some time ago discussing the challenges facing people with disabilities. And he has to be given credit because he has been a strident advocate for legislation to protect and to facilitate persons with disabilities. So happy Valentine's Day to him as well. Parliament recently passed the Sexual Harassment Act. It has been long in coming and I believe was long overdue. Sexual harassment has long been prevalent in Jamaica. We're not talking just about rape and carnal abuse. There are laws with harsh penalties to deal with that. And each year the police report that about 1,000 cases were filed in the court where persons are arrested and placed before the courts for rape and carnal abuse. I suspect that that is just a fraction of the number of instances where these crimes are committed because there is good reason to believe that the majority of them are not reported. Not to mention the instances of incest or incest. Fathers having sex with their own little girls that never see the light of day and are not punished. But sexual harassment takes many forms, some of them subtle, but still having a devastating effect, especially on young, vulnerable women. It happens at the workplace. The boss man or the supervisor pressuring an employee to come have some fun. And if she doesn't agree, she runs the risk of losing her job or being denied a promotion. It happens at social gatherings, on public transportation, at educational institutions, in multifamily residences. It happens almost everywhere. Sometimes it is not crude or explicit. It may be unnecessary or unwelcome touching, or insinuations or gestures, or sexually toned remarks that make a person feel uncomfortable. And you know, it occurs at all social levels, uptown, downtown, midtown, round town, out of town. It occurs at the workplace. It involves senior executives, middle management, shop floor, factory floor. Domestic helpers are perhaps the most vulnerable. They are most likely to be in a single employee situation where they have no protection in numbers. They are relatively easy to replace. Just call an employment agency. They'll send you another one. A domestic helper that has rent to pay and children to feed and send to school may find it difficult to repel the advances of an employer who believes that her services should involve more than just tidying the house and preparing the meals and doing the laundry. The Sexual Harassment Act was designed to deter and to provide remedies for this kind of behavior. We're going to examine that legislation today to see how far it goes, what relief it provides, and how effective we can expect it to be. It is not unfair to say that sexual harassment has long been part of our culture, our tradition. We are a flirtatious people. We men in particular have grown up with this macho syndrome. We have long believed that women were created for our youth and satisfaction. That, like the Adam and Eve argument, women were given to us for our companionship and our pleasure. And they have a duty to make themselves available to us. And you know, that's the way we think, that's the way we behave. But yet we wouldn't want other men to do to our daughters, to our sisters, or to our mothers what we think it is perfectly right, perfectly all right to do to other people's daughters and sisters and mothers. Well, you know, the world has changed. It has woken up. In many countries, including America, women were not allowed to vote until long after men were doing so. In some Arab countries, women are still denied the rights that men enjoy, even the right to drive a car, the right to be on the streets by themselves, the right to be seen in public without having to cover up themselves from head to toe, not to mention the right to own property. In Afghanistan, girls are not allowed to go to school. They don't have the right to be educated. Here in Jamaica, we are not as primitive and as uncivilized as that. But our attitude toward women needs a whole heap of fixing. And if we men don't get our act together and accept that women are our equals and deserve the same respect that we expect from them, we may have to come to terms with the superiority of women in terms of their achievements. Look at the performance of CXC students. Look at the enrollment at our universities. Look at the gender balance at management level in both the public and the private sector. Women in Jamaica are outpacing the men. The long struggle for the recognition of women's rights has advanced and has matured. Sexual harassment is one of the vestiges of that historical discrimination that had to be addressed, and thankfully we have sought to do so. But legislation can do only so much. Today we are going to examine the provisions of the Sexual Harassment Act to see what it says, what it illegalizes, and what are the procedures to deal with sexual harassment when it occurs. How convenient, how victim-friendly, and how effective those provisions will turn out to be. But it would have been good if we didn't have to rely on legislation. It would have been good if our instinctive respect for women and our recognition of their equality were such that we didn't need any law to protect them from our predatory behavior. But that requires a cultural change. Laws do, in fact, influence behavior. That is why we don't normally drive the wrong way on a one-way street. But ingrained attitudes require a socialization transformation. And we need to concern ourselves with what we are doing to bring that about. How we bring up our children so that they will become adults with a different mindset. And today we're going to look at some of the nuances, the unintended possibilities, like persons maliciously using the protection and procedures provided by the Act to cause trouble for people and damage the reputation of people who them have something against. If a man is wrongfully and vexatiously accused of sexual harassment at the workplace, it can cause a whole heap of problems at home, with his wife, with his children. The law makes confidentiality a requirement, but we know that confidential matters often leak out, and with the unbridled social media that we have now, someone's reputation can be severely damaged. What does the law provide to prevent that, and what redress does it offer if it happens? The Sexual Harassment Act is gender neutral because men can also be victims of sexual harassment. And I imagine that in this era of gay rights, it has to be sexual orientation neutral as well. That's the subject of our program today, sexual harassment and the law that has just been passed. How will it work? Will it make a difference? Will it empower those persons, especially women, who have had to contend with harassment day after day? We're going to delve into all of these matters today, and we have some very illustrious persons lined up to talk to us about this. And I'm so pleased to welcome. Oh, you want me to take a break? Let's take a break, and when we come back, we bring on our first guest. Today we're talking about the Sexual Harassment Act that has just been passed in our Parliament. And I'm pleased to welcome as our first guest on the program today, Senator Donna Scott-Mottley. Donna Scott-Mottley, welcome to the program.
Good morning. I'm not sure how to refer to you. I don't know if I say former Prime Minister, if I say
No. My name is Bruce. Mr. Golding died in 1995.
I'm delighted to be on your program. I wish you happy Valentine's Day, and happy Valentine's Day to all your listeners.
Thank you so much. Donna, this is the first time you're on the program. Unless you insist it won't be the last.
I was really honored to be asked.
Tell me, you were a member of the Joint Select Committee that deliberated on the Sexual Harassment Act. Tell me, as a legislator, as a lawyer, and perhaps most importantly as a woman, because women are predominantly the victims of sexual harassment, how effective can we expect this legislation to be? Has it gone far enough? Has it gone too far? What can you advise us?
I do believe that it has gone too far. And it sounds strange coming from me that it has. But in some ways, when I go through it and when we were debating it, I did have some challenges with how it had evolved. And let me tell you what I think happened, Bruce. Because of the Me Too movement, primarily, which brought a lot of these issues to fore, and because this is something which had been endured by women from time immemorial, but they had not been empowered to speak out about it. There was a lot of passion in the presentations and a passionate and emotional response from legislators as well, because we are only human. The question that I asked myself when we were actually debating it is it going to be a bit unwieldy in its implementation? And I suspect it might be. Now, let's look firstly at what it covers. because it has to be on unwelcome sexual advance. And the definition of an unwelcome sexual advance is very, very wide. That is not a problem, in my view. The problem is how the legislation unfolds. Because one of the requirements, and it is a critical requirement, is that there has to be a policy statement from all the employers and different institutions. And this is where now I believe that we are going to have some challenges in how we ensure that that is done and how we monitor it.
But pause a moment, Donna,
Yeah.
because I looked at the legislation. And I believe that there is some provision in the schedule as to what that policy statement should contain. But how much flexibility does an employer have? In other words, if I work at company X, am I likely to run into one policy statement, and if I go to company Y, is a different policy statement?
Well, I think not, because although I myself, I didn't like the way the first schedule was drafted, I thought it should have been as simple as possible so that everybody could understand it very clearly. The basic requirements are contained in that schedule. And it covers exactly what it is that we want you to pay attention to. What I was going to say, Bruce, is what level of organization, if I have 2 employees, for example, am I required to have a sexual harassment policy in place? How do I administer it, and so on? And I think there are some issues that we will have to clear up.
Well, very interesting you raised that. What about the person who employs a domestic helper? Does he have to put a sexual harassment policy in place for that one helper?
Well, the legislation did not address that, but let me say that it does make provision for such a person. Because whereas in a workplace, there are some processes you have to go through under the legislation. For somebody in that category, they can go straight to the tribunal to seek their redress.
Yeah, I noted that.
It's a comprehensive process.
I noted that. But the question I'm asking is whether the requirement for having a policy, does it mean that somebody who is employing a helper has to hand that helper a sheet of paper that says this is the sexual harassment policy in my home?
That's a point. That's a point which was not ventilated. And as I said, I see some issues which emerge. But let me be very fair to the legislators, of which I'm a part. This Sexual Harassment Act actually has a review clause of 18 months.
Yes.
Now, it's interesting that we even have that time frame, because 1 year is given to all the persons, the employers and the heads of institution.
To comply.
They have 1 year to comply and to put this policy in place.
Mm-hmm.
So I'm not sure how we will we'll be able to analyze what it is we need to look at. I think it is a recognition that there are going to be some issues that we would have to address very quickly.
Has the act been brought into force?
It has not been brought into force as yet.
Do you have any idea when it will be?
Well, the minister had promised that it would be very soon, but I have had no indication of that, and I noted that it was not mentioned in the throne speech at all.
Well, tell me, you know the structure of legislation. Many laws that we pass are impotent without regulations. Are there regulations that will be required to give effect to the provisions?
I think it is critical that we have the regulations. Some of the issues which I am concerned about and that you have raised could be addressed in the regulations.
Well, so, where is that at? Do you know?
No, I don't know. It's not so easy for a member of the opposition to be able to, follow those kinds of timelines.
I understand. I've been there. Tell me, Donna. You might have. I haven't done, but you might have looked at comparable legislation in other countries. How does ours compare with theirs?
Ours is, I think, far more complicated. Belize chose an option which is more simple in the sense that Belize, you go to the court. And the court can deal with all these issues. There are, special provisions and so on. In Barbados, you had two layers. So you had a chief labor officer being involved, and then after that, if necessary, a tribunal. We have the structure at the workplace with the HR department and so on, and then you go to the tribunal if you're not happy with the outcome.
Well, there are a couple of questions I want to ask you on that, because I've looked at the legislation over the weekend, and a couple of things jumped out at me. First of all, it explicitly says in Section 2, subsection 4, that it does not apply to persons under 16 years of age.
Well, I can address that, and I can tell you because I was almost insistent on that clause. The definition of a sexual advance or sexual harassment is an unwanted and unwelcome sexual advance towards a person. I was concerned that if we did not rule out children, persons under the age of 16, we would be suggesting that a child could welcome a sexual advance.
Donna,
it's very important to me that there should be no notion of that. Remember that...
I understand that, but, it is possible that they might.
That there might be an unwelcome sexual advance?
That they might welcome.
Well, we have other legislation which let
us discuss that, because I took the opportunity to look at the Sexual Offences Act, and it has a section that deals with sexual matters relating to children. It speaks about
grooming.
It speaks about sexual intercourse. It speaks about touching. It speaks about grooming. Mm-hmm. But then when it gets to grooming, it is subject to a provision so that there must have been at least 2 earlier occasions. So I ask, when you look at the Sexual Harassment Act, it speaks about demand or request for sex, sexual suggestions, remarks or innuendos, any other physical or gestural, verbal or nonverbal, visual conduct of a sexual nature. What happens, Donna, explain to me, with somebody who does those same things, demands or requests sex, sexual suggestions, remarks, innuendos to a 15-year-old girl? What happens, for example, with the taxi operator who picks up a 15-year-old student and decides to chat her up and try and negotiate something? How do we penalize that? I mean, we can't be protecting the over 16-year-old, but the under 16-year-old are left to the mercy of the taxi operator or to the person on the public transport who can grope them.
Bruce, you are one of the most experienced legislators. You have you have looked at legislation through the lens of a lawyer, although you have not been formally qualified. Now, one of the things is that one has to be careful about how you mix the different concepts in legislation. If your observations are quite valid, but what we ought to look at is, for example, whether we need a further amendment of the Sexual Offences Act, whether in fact the interpretation of those clauses can in fact cover the instances you are raising.
Donna, let's look at...
We cannot breach an honored precept
Yeah.
which is fundamental to the way that our society functions, to say that somebody that age can welcome a sexual advance.
But it's not a question of welcome. It may be very unwelcome. But for example, we have had, as you know, cases brought before the courts where teachers in our schools are found guilty of having sexual relations with students.
Yes.
So what happens to a teacher who sees this 14 or 15-year-old girl who may be physically well developed and endowed, and then starts making all sorts of suggestive remarks, and not grooming in terms of the Sexual Offences Act, that's how that is defined,
Yes.
but definitely trying to see if he can influence her to come have some fun. That like a 14 or 15-year-old girl is more vulnerable than the 30-year-old woman at the workplace. What are we doing to protect her?
Well, the point that I'm trying to make is that her protection would not come under this legislation.
But it doesn't come anywhere, Donna. Where is it? I can't find it in the Sexual Offences Act.
I would have to go back, to be fair, and to look at the Sexual Offences Act from that perspective to see if the touching section and so on would cover.
No, leave out the touching. Leave out the touching, but deal with what is in the Sexual Harassment Act. The references, the sexual suggestions, the remarks, the innuendos, the winking.
Yes.
The showing of pornographic images.
Yes.
Christ, man, how could we have left that out?
Because we cannot have a definition of sexual harassment, which is a well-established definition used in other legislation and used in the CARICOM model, which says sexual harassment means the making of an unwelcome sexual advance towards a person by another person.
It seems to me that we perhaps need to go
because
we need to go put together another piece of legislation then.
And that listening to you and sharing thoughts with other persons, that is perhaps the way that we redress the situation.
Let me raise some other issues with you, Donna, because I have a lot of respect for your legal mind. Sexual harassment is not a crime. It's not a crime here. I don't think it's a crime I know it has been made a crime in some limited respects in France. But the law provides for administrative remedies, including compensation.
Yes.
But what about civil remedies? Does the act that we have just passed provide a statutory foundation on which victims could sue a predator?
Well, what it does give is that the tribunal has the right to make an order for compensation for damages, and it takes the tribunal takes into account the feelings, the emotional distress, and so on of the person who has made a complaint.
Fair enough, but let us say the tribunal. I keep interrupting you, and I really shouldn't.
No, that's fine.
But let us say the tribunal were to make a ruling to say that you must apologize, and the employer must issue a letter of reprimand and so on. No monetary compensation, because that is within the authority and the discretion of the tribunal. The question I'm asking is, can that victim go to court and sue that accused on the basis that, look, this person caused me emotional distress? This was the ruling of the tribunal, but I am not satisfied that has addressed. I am suing this accused for $1 million. What I'm asking is, can the court? I don't see anywhere in the legislation where the court could say, well, what he did was against the law.
In terms of causing her emotional distress?
Yes.
Emotional distress, humiliation, and feelings really are not a feature of the criminal law.
But I'm talking about civil law
court,
now, civil.
the civil court can take that into account. Now, the question which you have asked is a very challenging question for me to answer, because we had a long discussion about that. And there were persons who felt that even if the tribunal made an order, you should have the recourse to the courts as well. That to me is not the usual way that one proceeds. One opts as to what avenue they will seek recourse. For example, you can't go to IDT and at the same time you are before the court. You have to choose the forum that you want to ventilate your issues. And I believe that once you do that, once you choose to go to the tribunal, you ought to be bound by the decision of the tribunal, because there is a way in which it can, the legislation actually does make a provision for it. So for example, the legislation provides that where the tribunal makes an award by way of a direction for the payment of compensation, the sum may be recovered by the complainant summarily in the court without limit of amount as a civil debt. And what the provision was that you could go to the parish court if that was a convenient avenue, where you have a limit on civil debt of $1 million, but in this instance, there would be no limit. So I do think that the law has made, taken a lot.
Yeah, but I want to pin down. I want to pin down the attorney in you, because I'm concerned. Let us look at the flip side. Let us say that I am a supervisor. I have been accused of sexually harassing an employee. When it goes to the tribunal, all the evidence indicates that I did no such thing, that this employee acted maliciously in filing a complaint. I know that there is provision in the law that if an employee files a false complaint, they are liable, they are criminally liable.
Yes.
But if I were to take a position, I am the manager, the supervisor. My reputation has been solid. My wife is now questioning my fidelity because of this accusation. If I were to go to the court to sue that employee, the court would probably say, well, we have no jurisdiction in the matter because there is no foundation on which we can consider your civil case to seek damages or compensation from this employee. Am I not correct?
I can't agree with you, maybe because you have invoked my legal hat. Because what I would do if somebody consulted me on that is I would examine what the allegations were, what were the words said, was it an accusation of a criminal offense being committed, and seek to find out if there's another avenue in which I can advance a case for redress. You see, the legislation did contemplate the circumstances where the complaint was false or frivolous or vexatious. But as you know, if you were to try to cover absolutely every scenario that presented itself to you in a law, it would become more and more unwieldy as you go along. So you have to have a very clear focus. And so, for example, I'm taking you back a little bit. So, for example, the conduct of a taxi operator or catcalling. Let me use a more disturbing one, catcalling on the street. You have to take a decision as to whether in this legislation at this time that is where you would seek to address it. So I would say he might have redress or she might have redress, because let us remember that this legislation is gender neutral. He or she might have redress, but not under this specific legislation.
What I wanted you to help me with, though, Donna, is a judge sitting in a civil court, would he have a leg to stand on in dealing with a matter like that? Or would he say, well, the legislation is deficient, you can't bring this matter here?
Well, he couldn't bring it under this legislation which I think is where we are narrowing the course for redress. He couldn't bring it under this particular legislation. The evidence would exist, but the avenue for redress would be different because this legislation does not make.
So apart from this legislation, the court could still consider the harm that may have been done to somebody's reputation?
Has a defamatory remark been made? For example, what is the nature of the accusation? Have you gone further than have you taken
if the accusation is contained in a complaint, formal complaint, that could still be defamatory under the law?
I don't think it would be defamatory under the law if it is in a formal complaint, because what we have, revisiting the Sexual Harassment Protection and Prevention Act, there are clauses which insist on confidentiality. And if you breach that confidentiality, it becomes a criminal offense. You are subject to being brought before the court and fines up to $1 million.
Yes. We're coming up, we're running out of time, but there's one important area that I want to explore with you, and I see this as a serious gap, a serious omission in the Act. Let us say a complaint is made to the tribunal. The tribunal conducts its investigations, its hearing. All the requirements of natural justice are observed. And the tribunal arrives at its findings and decisions. It makes an award.
Yes.
Now, a no monetary reward, the law says that is recoverable summarily in a court. But the award may not be monetary. The award may involve, and I'm quoting here from the legislation, to perform any reasonable act or course of conduct, to reinstate the complainant.
Yes.
In an instance where the complainant may have been separated from his or her job, to take such action as directed to ensure that the conduct ceases. The question I put to you now as one of the legislators that agonize over the whole of this something, what happens if the employer doesn't do that? I don't see any penalty, any remedy in the law. So he can ignore the tribunal and he faces no punishment?
No, that is not so, although I cannot immediately put my hand on the clause. There are consequences for the failure to obey the instructions of the tribunal.
Well, when we hang up, I'd love you to find them and email them to me because I can't find them.
Yes, I know.
I mean, if for example, he fails to reinstate the person, I don't see any consequence in the law.
No, because remember that you have this act does not exclude the right to go to the court.
No, you go to the court to deal with monetary reward.
No, not only that. All of your rights before the court are preserved. It doesn't exclude you from following through.
No, Donna, hold on.
Let me give you
I'm not a lawyer, so I'm being presumptuous now in arguing with you. But tell me now, if the tribunal says you are to perform some reasonable act or course of conduct, you are to require that supervisor to undergo some sexual therapy, and the employer doesn't do that.
Okay. So
there's no consequence in the law. I mean, the employer can stick his 3 fingers with one sticking up in the air at the tribunal.
No.
And say, well, I see what you say, but since you don't have no power to punish me, well, to hell with you.
I'm trying to find the clause, which I cannot immediately pick up. But I know that we spent a lot of time also examining that and putting in place the remedies.
Well.
And in addition to that, we also, after we deliberated in that manner, we also ensured that at Section 38, any person who was dissatisfied, and dissatisfied is fairly broad, with any decision or award of the tribunal could appeal to the Supreme Court. And that is what I'm saying, that even if I am incorrect and the tribunal does not have any rights to insist on the enforcement of the judgment, there is recourse which was protected under the law. But I promise you that I am going to look for that clause and I'm going to send it to you. And I do apologize for the fact that I cannot immediately put my finger on it because, it is 29 pages.
Yes. But I appreciate that, and I'm out of time, and I really appreciate your coming on today, Donna. Thank you so much. You've been helpful to us.
It was my pleasure. Thank you.
And
Thank you for inviting me.
This must not be the last time. Promise me.
I promise you.
Okay. Senator Donna Scott-Mottley, we're up on the 1 o'clock break. We'll be back in a short while. We're discussing today the Sexual Harassment Act that has just recently been passed by Parliament. I don't know if the Governor General has signed it yet. I don't think it has come into effect yet. But it was designed, crafted to address a long-standing problem of sexual harassment, predatory behavior, disrespecting women. It's gender neutral, but women are predominantly the victims. We had Senator Donna Scott-Mottley on earlier. We now have another member of the Joint Select Committee that deliberated on the bill, put it together, made its recommendations to the Parliament. Senator Natalie Campbell-Rodriques. Natalie, are you on my line? Not on my line.
Yes, I'm here.
Don't tell me that you're here when I don't hear you. How are you? You're gone again.
Here today.
Hello?
Yes.
You're there, Natalie?
Yes, I'm here.
Well, don't leave me again. Stay where you are.
I'm right here.
Tell me now. We're talking about the sexual harassment bill. You deliberated on this.
Mm-hmm.
Many years ago, we passed the whistleblower legislation.
Right.
Which was intended to protect people who expose wrongdoing in the public service. And I was disappointed because I brought that legislation to Parliament, no? And I was disappointed that for many years, not many people avail themselves of the remedies and the protection that it offered. I get the impression that it is getting a little better now. But what are your expectations in terms of the Sexual Harassment Act? Are people going to avail themselves of the provisions and the protection, or are people still going to be intimidated from filing complaints when they are the victims of sexual harassment?
Well, Mr. Golding, just a couple things in response to that. But before I answer that question, I heard you ask about whether or not the Governor General has already signed. The date of assent was November 2 last year. So, right, so we're waiting on the minister to, of course,
bring it into effect.
Yes. Well, for it to then be gazetted and be operational. But just to remind people that there's going to be a gap year when things are being put in place and for everybody to get used to it.
What about the regulations that may be required to really give effect and teeth to it?
Right. Those are not yet ready, but the minister, who is Olivia Babsy-Grange, has committed to having it done in the shortest possible time. And those of us who know Minister Grange know that when she puts her mind to something, it actually happens. And this is very high on her agenda. And that leads me into whether or not, what you're saying about the Whistleblower Act is quite interesting. And it does leave the question as to, can our culture take up the tenets of this particular set of laws, and actually make it operational so that it affects the lives of people? And it is an important question, because there are those who have said this sexual harassment bill is counter to our culture. And so you wonder what's going to happen. But given that it is very specific to the place of employment, to institutions, and to landlord and tenant issues, I think we will see a greater take-up of the law being used than if it were a general law affecting just the wider society, whether the guys at Devon House stoplight or whether you're at the National Stadium or whether you're in the market. So I think the fact that the legislation is so very specific, we will see a greater use of it. Now, also, we're a couple of years out of the Me Too movement. And I think because of that, people are more aware and realizing it's not okay. It's not okay to be harassed at all at the workplace. It's not okay for your landlord to harass you in exchange for the rent if that's not what you want. So I'm very hopeful. And one of the things I'm hoping for from this, you asked about my expectations, I'm hoping that the law will be utilized in such a way that in short order it can be expanded into other areas outside one.
Let's look at a practical scenario, because this is where the rubber hits the road, no?
Yes.
Look at a scenario at a workplace where you have somebody who is in a senior position. That person can fire, that person can decide who gets promotion, who gets a raise of pay. That person may be harassing an employee. And that employee may be scared of complaining, no matter what the law says. They may be worried that that supervisor, that manager is going to find a way to get back at them. That poor employee looks at her colleagues who she has lunch with in the canteen every day. And the colleagues may be sympathetic. But they're also worried about their job security. And they're worried about their promotion and their raise of pay. So they feel that they have to keep the distance. The victim is in danger of becoming isolated, becoming a pariah. Is the law indifferent to her situation, or is she being put in a position, or is she being not put but left in a position where she say, well, the law is good for those who want to take that chance, but I'm not taking that chance?
And that's a serious concern, and it is something that we deliberated on, because the way the law is written, the person who is being harassed is supposed to report it to their manager. And then the manager acts accordingly, and it is brought to a tribunal. Now, if that person who does the harassment is the manager to whom it should have been reported, the employee has a right to go directly to the tribunal.
Yes.
Themselves, so they don't have to worry that that person won't bring it, that manager won't bring the case forward.
And I imagine that would be critical to people like domestic helpers.
Exactly. You can go directly to the tribunal, because we wanted to ensure that persons didn't feel as though they could not get their matter addressed if it was from a superior person. Now, in terms of what happens, why do you feel afraid, etc., etc., what we have done is put in that step that I just mentioned to you. And a note is in there from the report to say that in the next discussion, we want to see how the bill operates now in this first iteration, how the act will operate. Now, from that, this act is supposed to be reviewed no more than 5 years from the time it was operationalized.
No, I believe it's 18 months. That's what I saw.
Hold on.
I think the act does say 18 months.
Yes, it's 18 months.
Which is short, because normally it says 3 years, but in this case it says 18 months.
Well, the reason it was moved, thanks for the correction, because the original drafting said 5 years, and we deliberated and brought it down. The reason it was brought down to 18 months is because there are several things there are a few things that we discussed that did not make it into this bill. For example, in terms of board members, how would you treat that? And this whole issue, we want to see how it actually operates, and then in 18 months you can go back to the table and fix any glitches that you consistency in the way it is working or not working. So the issues you have raised, other than the person being able to go directly to the tribunal, we want to see how things like that actually take place and operationalize. And so the 18 months time, we will review the set of laws and see if any changes need to be made.
But tell me, Natalie, and I said it in my opening comments, but I believe that you also alluded to it. The problem of sexual harassment in Jamaica has some pretty sturdy cultural roots.
Yes, it does.
How do we root that out? Because I'm not sure legislation can do that. How do we retrain the minds of our? I believe, you see, and don't ask me to expand on it because I haven't cleared it up in my own mind. But in terms of many of our social problems, our crime and violence, in terms of many of the social ills that we have, I'm almost at the point, I don't tell you I've reached here yet, when I believe that if we're looking long term, and I'm trying as I get older to try and see if I can extend my vision, as we get, if we're looking long term, I'm almost at the point where I say, we have to draw a line in the sand. Not to ignore the social challenges that we face now, but to look at those little kids that are entering the basic schools and say, how can we ensure that they don't fall into that rut? How can we ensure that those children, the 4 and 5 year olds, are exposed to the kind of socialization that will make sure that when their hormones start to develop, they are going to have built into them a sense of respect for other people, a sense of respect. If the boys must have a kind of almost reverent respect for women and the sanctity of women. How do we get that kind of social transformation? Because quite frankly, if we don't, that tribunal will have to meet 24 hours a day.
You're correct, Mr. Golding, and it's a discussion that happens so often, but the actions need to follow the discussions, and it's going to take behavioral change, communication to make it happen. So I don't know if you remember in the 80s, we used to have these ads, 2 is better than too many. And if you talk to anybody who is 40 or over, they will remember those ads because they were so effective and it got people thinking, and it actually led to some behavior change. We're going to need billboards. We're going to need radio ads. We're going to need jingles. We're going to need skits. We're going to need the church. And most importantly, women in the society are going to have to change the way they socialize their sons. And women in the society are going to have to change what they accept as behavior which should be accepted.
But you know what worries me in that? What worries me in that is which of us are going to come forward with clean hands? I mean, when you look, for example, Natalie, at the numerous, because I'm getting frightened now, the numerous instances where pastors are abusing little girls in the church. I mean, you find yourself in a position where you say, well, all right, we're in a crisis. We need a behavioral change. We need a transformation. Let us find the institutions that we can empower and rely on and vest in them the responsibility now to lead this charge. But
Mr.
But Natalie, I don't know which institution to trust anymore. I mean, teachers are messing around their little 14-year-old students. Pastors are messing around their 11-year-old Sunday school or Sabbath school attendees. What the hell is going on?
What is happening, though, in many of those cases, Mr. Golding, if we were to dig, we would find that the parents knew that the pastor was harassing the children.
Yeah, but that don't vindicate the pastor.
No, it doesn't. What it does is say is Us as parents, us as mothers and fathers have to stop allowing our children to be victims because we feel that the person who is the abuser or the harasser is above reproach.
Agree with you 100%. Agree with you 100%. But when I talk about the kind of transformation that is necessary, it has to go from top to bottom.
Absolutely.
From top to bottom. I mean, I know of situations that I can't say publicly.
Mm-hmm.
But I mean, I know of situations where helpers have been abused by some. Let me not go no further, yeah?
Right, but you know what else? Maybe it's best you don't go any further on air. But what I'm saying, though, Mr. Golding, is we need almost like a broken window approach to get the change that we're going to need to make a big dent in the cultural acceptance of harassment. And it's harder for our men who are being harassed.
Well, hold on. Yeah, okay, fair enough, yes. But I want to kind of turn the discussion almost 360 degrees around now.
Mm-hmm.
One of the things that worries me is that in order to deal with the errant behavior of many of our menfolk, we may find ourselves in a position where we are forced to do things that make relationships between people cumbersome. Now, I mean, for example, and you have known me for a long time, so you perhaps have been exposed to some of it.
Right.
I tend to be very frivolous, particularly with women, and I do it sometimes in the presence of my wife. I mean, I will see a lady and I will say to her, listen, if I was married to this lady, I would be I'd be checking you every day, That may now be sexual harassment.
Mm-hmm.
No?
No, because specifically it has to be a situation where the person receiving the affection perceives it as harassment.
But she might. She might say, what is wrong with this married woman, this married man standing up in front of his wife and telling me them kind of something?
But if you then stop and acknowledge that she has told you that that is inappropriate for her, then you're okay. When you're not okay is when you continue.
All right, fair enough. But the problem is, though, I mean, I go back to when I was a youngster, right? And youngsters, your hormones are getting into your brain. And you're running up and down all over the place. And you find yourself down at St. Andrew High School at 3 o'clock when the girls are leaving school.
Mm-hmm.
A lot of the things that I did as a youngster, which was par for the course, I mean, this was normal relationship building, would now be considered offensive. And I worry whether my grandsons are going to be able to find a wife because it may be so tortuous a process that they're going to have to go through. If they are to dot the I's and cross the T's properly.
Well, that's where you yourself and the parents of the children and grandma comes in to speak. We have to change the way we socialize our boys because times have changed and women, many girls back then may have found the behavior offensive, but it was such a norm that they felt limited in their response, and so they just smiled and accepted it. But it was also offensive. So now the Me Too movement especially has sort of strengthened the resolve and strengthened persons feeling they can stand up and say, I find this offensive. And the only time that becomes a problem is if the person persists and if the person does not, the person who is receiving the affection, once they say it clearly, this I find inappropriate, the person needs to stop.
Fair enough.
Stop.
We're running out of time, but Natalie, thank you very much. I think it's good that they're going to review the act within 18 months.
Yes.
And I think it's going to be important for us to keep the debate going because I've seen some gaps in the law. I'm concerned about the implementation of it and how effective that is going to be. I discussed with Donna Scott-Mottley, for example, the fact that if an employer doesn't comply with the directions of the tribunal, other than the monetary award, I don't see any sanction in there for him. So it seems to me that the work is going to have to continue if we are to make the thing effective and if we are to provide women with the protection that I believe all of you legislators who worked on the bill were determined that it should provide. But thank you so very much for coming on today.
Which is the purpose of the 18 months versus 3 or 5 years. Thank you so much for having me. And just having these discussions in the media space will help the process of making those changes that are necessary.
Thank you very much. Senator Natalie Campbell-Rodriques. We're talking sexual harassment today. We'll be back in a short while. Welcome back. Jamaica Live, we're on Bridge 99, and we have linked with Irish in New York, and I believe Beauregard has been listening to me and I'm not paying him no mind. Big man.
Yes, sir. How you doing, Mr. Golden?
How are you?
Everything all right, and I had a wonderful weekend.
Tell me something. You get any visit from the sun recently?
Yeah, the sun there today, it's out today. 27 degrees, but the sun out same way.
Yeah,
we had some snow Saturday into Sunday, but that clear up now and gone, so.
But if the sun is out and it's 27 degrees, the sun need to kind of turn up the heat a little bit.
Yeah, hopefully. Well, today is Valentine's Day, and a lot of love is in the air, so hopefully the lovers them.
So whole heap of hooking up going on.
Yeah, maybe the lovers them can warm up the place,
But you're good though.
Yes, everything is all right. Everything is good on
Good
this
to
side.
hear you. We're talking sexual harassment today, and you're
Very
up there,
interesting topic.
you're closer to the Me Too something than we are out here.
Yes, it's
But we have also taken note of the fact that we have to stop this beating and battering of our women particularly.
True indeed, true indeed.
And we're past the law. What we're discussing today is how effective it's going to be and whether it is really going to provide the relief and the protection that our women deserve. And I keep saying women because they're the ones who are mainly the victims, but the law is gender neutral, no? So it applies to men who are the subject of sexual harassment as well. But that's what we're talking about today.
All right, I'm listening. Looking forward
Nice
to
to hear you.
All right, sir. You too.
We're going to be talking now with Mr. David Wan, who is the president of the Jamaica Employers Federation, because so much of the workings of the legislation of the Act will rest on the employers, what they are required to do, what they are expected to do, and as I've been raising in the discussions, what happens if they don't do it. David Wan, welcome to the program. Welcome again, because you've been here before.
Yes, afternoon, Mr. Golding, and to your listeners.
How you been?
Everyone. I'm fine, thank you, sir, and I hope you're keeping well.
Man, I give thanks every day of my life.
Oh, boy.
Tell me now,
Mm-hmm.
the Sexual Harassment Act, what is the general attitude of employers to this piece of legislation? What has been their response?
Well, most of our members, Mr. Golding, are feeling that it is a piece of legislation that's overdue. I think there's a lot of feelings in the country that some employers are, reluctant to embrace it. Those wouldn't be my members. My members are very much interested in the compliance and the reduction of harassment in the workplace to make it a decent place to work, so to speak. A decent work agenda. That's part of the decent work philosophy. So it's accepted. We have a year in which to get ourselves ready before there will be actual monitoring and so on by the authorities. It was passed last December, and we were told we have a year to get ourselves ready for the actual monitoring and compliance inspections.
Let me ask you this, David, because it's not something that I wouldn't imagine that you'd have any data on it, but let me ask you, from your perspective, how prevalent is sexual harassment at the workplace?
Well, as you said, there's no data. I would venture a guess that if you were able to find out across the spectrum in Jamaica, including public and private sector, I would hazard a guess of 25% or more. That's my sheer guess. There's no data to that. But I want to make a point, though, Sir Golding. The public sector, which this act will affect the public and the private sector. But there is evidence worldwide that in a part of the public sector, there's a tendency for it to be quite prevalent. And I speak about the uniformed services, not just Jamaica, all over the world, the military, the police, the correctional services, the fire services.
Well, look at what is happening in the Metropolitan Police in London now.
Yes, exactly. So I have said publicly, I encourage the authorities to try and make sure that those sectors that have been shown to be, globally very prone to this kind of activity, to try to make sure we are in good shape for this law, because it will only embarrass the government if it's found out later on that there is, non-compliance in these areas from those institutions that they control.
What has been the practice of your members? Because you can only speak for your members.
That's right.
But your membership would include some of the real big corporate bodies in Jamaica.
Oh yeah.
What has been their practice even prior to the legislation being enacted?
Some of them.
Do they have robust policies that are effectively monitored and enforced to deal with sexual harassment?
I would say the majority of them don't at this point. There are some who have made simple statements about that they don't condone sexual harassment in the workplace, but it has not gone into a very granular mode into which this act is taking us. For example, you're required to put a statement of your policy of sexual harassment in a place that's visible by all employees and customers, etc. So this thing takes it to another level. So I would say not very many companies have the kind of regime that's being put forward by this anti-sexual harassment bill as yet.
Now, within the 12-month grace period that has been provided in the law,
yes,
employers are going to have to do a number of things. They're going to have to establish and provide a policy statement on sexual harassment.
That's right.
They're going to have to put in place formal disciplinary mechanisms to deal with complaints.
That's right.
They're going to have to maintain a register.
Yes.
How responsive, how willing are the employers going to be to do that? And to what extent are they going to consider that this is yet another burden on doing business that they have to contend with?
Well, the more enlightened of them will embrace it, so to speak, because bear in mind, 59% of all the managers in the private sector, by a survey, are female. So you will definitely have compliance from those companies where there's an abundance of female managers. But because the law has some teeth now, this act, you will find those who were not so interested in complying, they will have no choice because it's a deterrent to have this thing on your record as a company and to suffer the fines that could be levied. So there will be compliance. Some not so willing, but have no choice because.
But there seems to me, David, there seems to be one hell of a hole in the law. I was discussing it with Senator Donna Scott-Mottley earlier, and she's a lawyer. She promised to research it, recheck the law. But I'm pretty clear in my mind. I took some time over the weekend to go through the law from beginning to end. The law provides that complaints will, if they can be resolved at the internal level within the company, the employment space, they go to a tribunal.
Yes.
The tribunal is empowered to do a number of things, including uh, handing down a monetary award, which can be recovered in the civil court. But apart from the monetary award, the tribunal is empowered to do various things to require the employer, to insist that the employer requires the person accused, if the person is found to have actually committed sexual harassment in whatever form the law defines it, to require that person to perform any reasonable act or course of conduct. It requires the employer, if the complainant was dismissed as a result of some sexual harassment vendetta, that the employee must be reinstated. It requires that the employer must take such action as it directs to ensure that the conduct does not recur. But up to now, and I went through it carefully, I can't find any provision in the law to say what happens if the employer doesn't do that. Now, there's no point in telling me, there's no point in handing me directions and telling me that I must do this and must do that. If I can skin up my teeth at you and say, well, yeah, but I'm not doing it, and there's nothing in the law that you can do to me if I choose not to do it. I don't understand that.
An act has been committed. I mean, I'm not following you 100%.
No, it says that if the tribunal says, yes, this is a case where this employee was sexually harassed,
Yeah.
and we are hereby directing that the employer must require the employee to issue a written apology, for example, that the employee must undertake not to interfere with that employee again, or not to associate in any way, that the that employee who was terminated because she didn't respond to the sexual advances, that employee must be reinstated forthwith. These are the kinds of directions that the tribunal can make under the law. But nowhere in the law does it say what happens if the employer decides that he's not doing it.
The only thing I know, is about compliance, Mr. Golding, is that once they get these inspectors going, well, I shouldn't speculate. I'm not going to speculate.
It is something that needs to be looked at. The one area of recourse that I found is where if the tribunal says that this employee must be given $100,000 of compensation, for example.
Yes.
Then if that $100,000 is not paid, the law provides that the employee can go to the court and get a court order.
Yes.
But outside of the monetary compensation,
right.
It seems to me to be one big kind of drain hole in the law that needs to be looked at, and I brought it to the attention of Senator Scott-Mottley, who promised that she's going to research it.
Yeah, it's a very interesting point.
But but what you're saying is that the employer, certainly those that you represent, the employers are not hostile to the legislation.
No, they're not. But you made a point about the tribunal, Mr. Golding, and there's a very important point I need to make. One of the biggest discomforts we have with the legislation is that once the employee has tried to get resolution to the alleged assault internally and is not successful in the company satisfying what they have brought up, they are able to go to a tribunal directly from that.
Yes.
Now, the regular labor legislation regarding employee disputes and the pathway to the industrial disputes tribunal must first go to a mediation point at the Ministry of Labor for an attempt to see if they can resolve the dispute without going to the tribunal. Mm-hmm. And I believe the legislation needs a checkpoint at the Ministry of Culture, which is the sponsor of this bill, to see if there can be a mediation before the employee goes to the tribunal. And why do I say that? There will inevitably be cases brought to the tribunal, both worthy of, going to the tribunal, as well as some who are frivolous. And what I don't want is for the tribunal to be packed up with cases that turned out to be frivolous and, penalize the ones who have the real solid cases.
I take your
So
point.
for that,
I take your point.
yeah.
I noted that the tribunal does have as one of its options mediation. But what you're suggesting is that mediation should be intermediate before getting to the tribunal.
That's right. And we've said it publicly and we told the ministry. Not sure what the response is.
It's an interesting point. I'm going to pursue that. David Wan, President of the Jamaica Employers Federation. Thank you so much. Thank you for joining me today.
Bye-bye.
We're talking about the Sexual Harassment Act that was recently passed by Parliament, signed by the Governor General in November, and is to come into effect shortly when the Minister Olivia Grange names the date. We're pleased to welcome to the program now Mr. Matondo Mukulu. You're not getting through to him. Lord, I wanted to have him on the program. He was the deputy, number 2 man in the public defender's office here. Somebody who is based in London. And somebody who had experienced, during the time that he served here. And he was one of those who had made a submission to the Joint Select Committee on this particular bill. And I was anxious to have him share his views on it with us. He's very human rights orientated, and I would love to have had his views, but he said we're having difficulty getting through to him. We're going to keep trying. But in the meanwhile, in reviewing the legislation, which is what we're trying to do today, I see some gaps. I'm not going to sort of slam anybody for lack of foresight or incompetence, because it's a very delicate matter, What is sexual harassment to some is just joking to others. I find, for example, there are some women who get very offended at the slightest little inference. Sometimes it is so well intentioned. You don't have no it don't have no intention behind it other than just making a joke. But some women are offended. And when I talk about re-socialization, that's part of the thing that we have to come to terms with. What are the things that are clearly out of bounds, and what are the kind of things that women need to be a little less offended about, because it will differ from one person to the other. There's one interesting aspect of the matter that we haven't discussed today, and that has to do with transactional sex. There are places in Jamaica, of course, where there's a market for those things or for those activities. And the question is whether or not that also is caught within the ambit of harassment, because in those cases the dispute may have to do not with the advances, but with the terms and conditions. But that's another matter. I'm not going to delve into that today. That is a honestness that I don't want to get into. We're still trying to see if we can get hold of Mr. Mukulu before we wrap up. I served in Parliament for many, many years, and I've sat in God knows how many Joint Select Committees that worked on legislation. Myself, not bragging or boasting, but myself contributed to the framing of some laws. And when you go into this kind of endeavor, very often you go in with one set of intentions, and 5 years down the road, 10 years down the road, you discover that what you intended is not, in fact, what has been achieved. That's the nature of the work. it is difficult to legislate human behavior because human behavior is based on responses, how people respond to particular impulses, how people respond to particular legislative, legal interventions. And I'm sure that the members of the Joint Select Committee that considered this particular bill agonized over that. I mean, they knew what they were trying to achieve. I was very surprised, very, very surprised when Donna Scott-Mottley told me that she felt that the law had attempted to go too far. And that I can understand that because, as I was saying before, you have to be careful that you don't get to a stage where, young people socialize, young people make approaches, make advances to each other. You have to get to a stage where you don't make it so difficult that a young man is afraid to even say to a girl, I like you. And, I'd like to have a relationship with you. Next thing now, the poor young fellow is accused of sexual harassment, even if it's not at a workplace setting. As somebody said to me recently, you don't want to get to a stage where when people are seeking to establish relationships, romantic relationships, it is not something that, has to be governed by a written document. You have to put it in writing and get a JP to witness it. And you send it to the girl. And her response has to be signed by a JP as well. Otherwise, you won't get into trouble. No. Emotions are not amenable to that kind of regimentation. So we have to be very careful. But at the same time, the trauma, the living hell that some of our women have had to endure over many, many years is not something that we can continue to tolerate. My own view, quite frankly, is that I think the Me Too movement has gone too far. I think that they have created a kind of sensationalism about relationships that one has to be careful. I'm not taking away from the fact that their efforts have exposed some terrible things. I mean, this guy Epstein, or whatever his name is, who eventually took his own life in prison, we are told, because of what he was facing. And there have been other cases. Remember that case of this guy, what was his name, Castro? Who had these girls imprisoned in his basement for years and fathered children with them and so on. And when he was arrested, he took his own life as well. So there's no question at all about it. That, I mean, we have had problems. But in all of these things, there has to be moderation, there has to be balance, there has to be a reality check, there has to be an acceptance that, look, we can't legislate how we breathe air. You can't pass a law to say, now look, you have to take so many breaths every hour and no more. If you find you're taking more than that, we're going to lock you up. Not everything can be legislated. And I think that when we're dealing with human relationships, particularly relationships of a sexual nature, I think we run the risk of trying to interfere with emotions. So we have to find a balance, and that is in fact what we're seeking to do in terms of how we discuss the Sexual Harassment Act. It appears that we're not going to be able to get through to Mr. Mukulu. I'm sorry about that, because I really was looking forward to his comments. So we're going to wind up now. I must tell my listeners that I'm not going to be here next week. I do have to travel next week, so I will be away. And I think the station is going to make some arrangements how to deal with the time slot. So I won't be back again until the following week. Next week is what? Next week is what? The 24th. So I won't be here on the 24th. And the week after that, I think, would be sometime in March. I'll be back that week. Beauregard, are you still there?
Yes, sir.
Listen, man. I'm traveling to London next week.
Oh, you are?
Yeah, I'm not coming down nowhere near where you're there. Because when I checked the temperature in London, it was like 51.
I'm sure eventually you'll find your way over here. If you want to start with London, you can start with London.
Yes, man. London is 51, and you tell me that you are what, 23?
Yeah, for now.
You know, listen, man, you can keep that. Tell me something. How long you been up in New York? How many years now?
3 decades.
3 decades?
Yes, sir.
You serious?
A very long time. More than half my life.
It's time you pack your bags and come back home. How often you come down?
When I get the chance, you know. Whenever I get the chance. Always working somehow.
Well, whenever you come down again, you shout us and let us know.
I will.
But hail up all the Jamaicans up there for me. This is Reggae Month, and we've been having a feast in terms of some of the programs. They've really produced some good shows to commemorate Reggae Month. I was watching one last night with all of the, the old-time people, the Freddie McGregors, the Ernest Smiths. That's all Leroy Brown on yesterday.
Yes.
Fabulous Five did a thing where they had a whole heap of Marley hits that they played, and it was really out of this world.
Yes,
so you guys pay attention to Reggae Month up there?
Yes, we've been celebrating since the beginning of this month.
Yeah.
So we continue to do that. We'll be doing that all of February.
Yeah, man.
Yesterday was also the Super Bowl. I say congrats to the LA Rams on winning the 56th Super Bowl.
Yeah.
Congrats to them. They defeated the Cincinnati Bengals.
Yes.
And speaking of performances, it was an exceptional halftime performance. It was a win for hip-hop.
Yes.
In seeing those legends on stage at the same time.
Snoop Dogg and them people, yes.
Yes, indeed.
Well, have fun, my friend.
All right,
have
you
fun.
too. And safe travels.
Yeah, man, and I'll catch up with you when I get back.
All right.
Okay, that's it for me for today. I'll see you not next week, the following week. Jamaica Live, Bridge 99.